I'm very glad to speak on this stage of the bill. Reform is much needed in this sector and it is welcome. But what is proposed here is not at all adequate because it lacks the necessary and broad consultation with our childminders, who are a fundamental and critical cohort. Our childminders have been virtually ignored in this, despite being a well of experience and wisdom on the issue of childcare. In addition, it lacks understanding and practical recognition of the criticality of the cohort, estimated at 53,000 childminders. It lacks the necessary thought and consideration to make the necessary TUSLA response quick enough, agile enough, and indeed timely enough. Crucially, it does nothing, absolutely nothing, to make sure that the parents using these 53,000 childminders can avail of the National Childcare Scheme. And bringing in and helping parents financially is what this bill should be about. Helping as many parents as possible. Parents put to the pin of their collar to make ends meet, with skyrocketing mortgages, rent, groceries, fuel, insurance, and then adding the childcare mortgage to their monthly outgoings. Sinn Féin stand fully with childminders and with all parents using them who want to avail of the National Childcare Scheme, as should be their right. We want to make it happen for as many parents as possible and to honour their choice in their childcare arrangements. So any support we give this bill comes with major caveats, and we will have amendments at committee stage. Because, as ever with this government, the need to be seen to do something overcame its duty to do something that has been carefully consulted on with all the key players. Something that has been carefully thought out as to the needs of children and the desires and wishes of their parents and childminders. That the government's focus has tended to be more on care in childcare centres is not surprising. It's in keeping with the centrist right ambition to commodify, monetise and profitise care in the first years of life and indeed in the last years of life, to uproot children and the elderly from home environments. And yes, many parents do prefer centres for their childcare. The quality of care is high and it can suit their needs, and we're all for that. But we're also for choice, because in practice, many prefer their child to be cared for in an at-home environment, either the child's own or the minder's. And it must be recognised that childcare and childminding are two very different offerings and experiences. With childminding, the child gets to know the minder's home as their home for the hours that they are there. It can be extremely stimulating and supportive environment for a child, in fact highly educational in that important sense. It can also be an extremely supportive environment for parents, because there's buckets of good advice when it's asked for, and above all, it's very flexible. Generally, since there are no late fees for pick-up, there are no parents on the Lewis or the Dart, or in my own constituency of North Kildare on the 115 bus to Kilcock, petrified at the thought of losing their childcare place because the bus is late again through no fault of their own. Draft regulations for childminders were open for public consultation early this year as part of the National Action Plan for Childminding 2021 to 28. Consultations closed in early May and their findings are yet to be published. But right now, despite the fact we have an estimated 53,000 childminders, so many of them solid gold for parents and their children, fewer than 100, and you heard that right, Minister, only 100 out of that 53,000 are registered statewide. That means only the parents using those 100 childminders can avail of government subsidies through the National Childcare Scheme. The parents using the other 52,900 are locked out of the scheme, and that to me is just bonkers, and Sinn Féin want to change that. Parents of young children are exhausted and they are broke. They need a hand, not a shove. From Sinn Féin's perspective, this change requires the government accepting that childminding is vastly different from other forms of childcare. With its vast depth and breadth of care and caring, we cannot understand why childminders haven't been listened to properly in this process. Input from them and listening by the government are critical if regulation is to work. We believe strongly that families need a childminding sector that is supported as an integral part of the wider childcare sector, and that this service must be maintained and developed into the future. As presented here, there is no incentive for childminders to sign up to the draft regulations. If he is serious about parents' choice and developing the mix for childcare available and covered by the NCS, the Minister needs to change tack quickly and to listen up. But our difficulties with the bill are about more than failure to listen or to include the 52,900 minimum children. We have serious practical and operational concerns also. For example, around Tuasla's capacity to register significant numbers of childminders and then to manage that caseload on an ongoing basis. Like, Minister, it just seems to me like that you are setting this up to fail. How are Tuasla going to manage that caseload? Right now, for some aspects, it takes a period of 3 months for regulation to be completed. There is every likelihood this time frame will increase and create a significant backlog, leaving children, parents and their minders in the lurch. In addition, there is an issue of fees and transparency. A yearly fee from the childminder will be required to cover the cost of inspections, but what this exact figure will be has not yet been disclosed. For obvious reasons, this has childminders worried. They fear that they could be caught for significant administrative fees over which they have no control. Equally, concerns have been raised with us in relation to the sharing of personal information online and in public forums. Privacy matters, and we would call on the Minister to ensure that he heeds this concern and takes it seriously. In addition, the length of time required to notify an age profile change has been set at 60 days. This isn't comparable with the unique nature of childminding, which gives families invaluable and cherished flexibility. You'd have to wonder whether this is more about accommodating Tuasla staff and less about looking after the minders, the children and the parents. Equally, we have serious concerns about some of the terminology contained in the bill. Childminders are asked to change their title to provider and their homes to premises. Demands that have no material value and depersonalise the unique offering of a home-based childminder and all the comfort this implies and offers. Equally, the bill stresses training and interview, but as concepts only, with no indication on what either will demand or involve. Who will do it, Minister? Who will pay for it? Who will examine it? What are the criteria that you're going to use? How will they be set? And by what and whose standards? It seems to me someone said, oh, training and interview will look good here, let's put it in. And I swear to God, honestly, it does. On top of that, there are further provisions that I believe attempt to constrain the unique offering of childminders. Far from constraining them, we should be consulting with them, heeding them and using their vast experience to inform government policy. The essence of the childminder-parent relationship is all about the personal safety, trust, flexibility, respect, kindness and common sense. Let's face it, in handing over our children over to a childminder, we give them the most precious things we have in our lives. We are far more concerned about their character and their kindness than we are about regulations, bureaucracy, regulations on day trips, signing in, signing out, nutritional requirements and complaints procedures. This works fine for a centre and it's very, very necessary for a childcare centre, but to me it would seem like a bit of a pantomime for a childminder to be engaged in. Childminders and parents would rightly dismiss it as the bureaucratic nonsense that it is. So please, Minister, I would urge you to listen to the actual experts here, the childminders themselves. Engage with them, talk to them and listen to them. The provisions of the bill, they feel removed, remote and cold, the polar opposite to the warmth inherent in the childminding experience. This bill can and must do better.
Deputy Conway Walsh.
Thank you, Cathaoirleach, and thank you, Minister. At the outset, I want to really acknowledge the really hard work, the really, really valuable work that childminders across the country do. The 53,000 childminders, I think they fulfil such a great role. I think all of us have. I know myself as a parent, not everybody has long or can afford long maternity leave. And my own two children went to an absolute wonderful childminder. I'll actually say her name because Sheila Wilson. And they were part of her family. and provided a really great, not even a service, but just as part of their family. And I know the difference that she made in their formative years in growing up that has continued on through their lives. So I want to acknowledge the wonderful work that childminders do and the fact that we couldn't do without them. Now, we have a number of concerns about this bill, and I hear what you're saying in your statement in the consultations and that you're listening and you want to get this right. So I'll take that at face value that you do. So I want to feed into you some observations. And the first one I want to feed into you is somebody who's already a registered childminder. And she says, I've been working as a childminder for the past 21 years in this country. I offer a wraparound service whereby the parents drop off their children in the morning and I do all the preschool and national school drop-offs and pick-ups. That's the flexibility that's required for childminders. I currently offer the NCS for parents as well. I run a very busy service and rarely have spaces. The children I mind usually come as babies and stay until they go to secondary school. They are family after all that time. There is no full-day care service in my town, so childcare is very limited, and I think we need to be cognizant of that when we look at the numbers and the numbers registered and the numbers likely who maybe are likely to register, the time scale that they need to register in as well. She says, I've engaged with my local county childcare committee in discussions about the new regulations proposed for later this year, and I have things I'd like to say about them. As a current TUSLA registered childminder that has been inspected on numerous occasions, I feel that it should be possible for me to seamlessly transfer to the new system without the need for home visits, further training, etc. Currently, I'm able to mind 2 children under the age of 15 months, and this works well for me. I see no need to change that. If that were to be reduced to 2 under 2 years, this will negatively impact my service. For example, this past year I had 2 children under 15 months and a further 2 under 2 years. With the ECCE scheme covering 2 years, it's not very often that I would have children start over the age of 2 years. And you can see that again in terms of other childcare provision that's after 2 years. It's most likely we will make childminding business unviable. I signed up to the core funding in 2022, and like everyone else who signed up, I had to freeze my fees. Now, the last time I increased my fees was 2012, and I'm sure that you will agree costs have significantly increased since then. I currently charge €35 a day with all meals included, and I saw for myself what she had included, and you talked about nutrition earlier on, what was included in those meals, and indeed her home that was so conducive to children having an environment to meet all of their needs. But she says if my numbers were to drop, my income will drop and I most likely will have to cease childminding. That's in a town where there's no other service. I run my service from home, therefore I run it like a home. There are times when people will visit on and off. During the course, the children are in my supervision at all times. I don't want this to change so long as the children are in my supervision. I see no issue with this at all. I currently have a visitors book and I will continue to operate this. In the regulations, it states that a childminder works alone. I would like on occasion to employ someone to do a few hours with me during the busy times. I think so long as the person employed is qualified and has Garda clearance, that it should be acceptable. It would only be to the benefit of the children and the childminder. Would it be so handy if I had appointments or I was sick, or to have somebody who could step in and take over? I feel so much pressure at any time I have to close for appointments. I'm very aware I'm making it hard for up to 6 families to find alternative care for the days. Have I my time? Am I still okay for time? Yeah. Yeah, it can be a very lonely job at times, and this would make it more enjoyable. This person may also double up as our emergency person. So I want you just to take hers, as a registered childminder, her comments into account to ensure that she is viable going forward, if that's okay. She also says she's received core funding over the past 2 years, and at present she has no idea if she will receive it again this year. It's been suggested that they're going to rethink childminders' payments, probably a lesser amount. And she's saying, okay, so that's good if that can be corrected. It's June and I've no idea what I'll have come September. So if my CF was reduced, I'd probably leave it, or she'd have to increase her fees. So that's good if that's all taken into consideration, Minister. The level of consultation with the sector absolutely has to improve, because these are the people who have the answers to how this can work for everybody. It needs to be inclusive, and it needs to be cognizant of the very unique nature and the service that childminders offer. And I'll finish at that. Thank you, Minister, but I think we have a lot of work to do here, and we'll work with you to do it.
I welcome the publication of this bill by the Minister. I hope this bill will finally put some shape on the consequences for providers who don't meet certain standards. It seems that the Minister has found a formula that will give TUSLA the powers it needs. Childcare providers, while subject to basic standards in child protection and business law, have existed in a bit of a grey space when it comes to regulatory oversight and enforcement. Hopefully this bill sets the standard in stone and we see compliance across the sector. It gives TUSLA access to the enforcement tools that have been lacking for some time. The lack of enforcement has been highlighted in this House on many occasions, and generally it's on the back of a national scandal. The new enforcement tools will allow TUSLA to issue improvement orders, immediate action orders, temporary closures and closure orders. It creates a transparent system that's straightforward and easily understood by those it applies to. It allows for formal information sharing for parents, which it hope allows parents better understand the services that they are placing their children into. Though I note that some concerns have been raised in this regard when it comes to childminders, as the lines between personal and business information can be blurred. Another focus of this bill is the introduction of fit and proper person regulations, which allow TUSLA access how suitable a person is when applying to be registered as an early learning and childcare provider. I don't think I've missed it, Minister, but it seems that the legislation lacks any sort of review how these new enforcement powers can and are operating. This might be something, Minister, that you could consider at committee stage. We've had improvements in the quality and oversight of early learning and childcare providers through different amendment bills to the Act of 1991, but it seems to be a very bit-part approach, overreactive instead of proactive, and previous acts have missed some key areas leading to problems with enforcement persisting in the sector. From the perspective of a parent, and from a child protection point of view, it's important that this bill plugs the current gaps that exist. The second aspect of the bill is the intention to bring all paid non-relative childminders in line with regulations in the coming years. I want to welcome the inclusion of a transition period as provided for in section 18 of the bill. While it's a legislative change, it's also an attempt to change culture within a huge sector, and I think we'll all agree this will take time for it to find its feet. It's estimated that there is 50,000 childminders throughout the state, but less than 100 of these are registered with the state. There's been very little consultation with those childminders who are impacted by this bill. I think that's a missed opportunity, and you need to bring the sector with you if we want to see these changes to succeed. I really think the Minister should engage with the groups concerned before bringing this to committee stage. There's also outstanding questions about TUSLA's ability to maintain this register, and the last thing I think any of us want is for backlogs when this is created. So, Minister, I would say to you, I think you need to go back, carry out proper consultation with childminders, and I don't think the big stick and no carrot approach, the big stick and carrot approach is going to work. I think it's doomed to failure. So I think it's important that we have everybody's voice heard in this and that everybody's interest is listened to. Thank you.
Thank you very much, Deputy Mitchell. Now we go to Deputy Sean Sherlock.
Corla, I'm reading with interest the Minister's words before the House this afternoon, and I quote from the Minister's speech where he says, and I quote, "The second purpose is to provide for the regulation and registration of childminders who work in the childminder's home through a phased approach in line with the National Action Plan for Childminding, and I'm committed to delivering childminding specific regulations that are both appropriate and proportionate, safeguarding children and providing assurance of the quality of childminding services while acknowledging the unique circumstances of a childminder working in the family home." So if I take the Minister at his word on that, then I would be hopeful that there will not be overreach by the state into that very special relationship that exists between a childminder and the person that she, for the most part, is minding, the children that she is minding. It's a relationship that holds a very special place in Irish society. And we all, I think, as parliamentarians, know who the childminders are within our own communities and know the countless numbers of children that they have minded. I am fearful that if the Minister's regulations, which he proposes to introduce, arising from this legislation, if they are too strident, that will have the effect of forcing childminders of long standing out of the profession. I'm fearful that if you introduce an inspectorate or a regime that goes into people's homes, that forces people to make significant changes to their own home, signage, where maybe furniture is placed, seating arrangements, toileting, all of those things that are part of an inspection regime in a formal setting, that would be a bridge too far. Now, I take the Minister in good faith. I don't think the Minister that is the intention of this regulation when it comes about. But I would just, insofar as I'm able to do this from this vantage point, caution the Minister and his officials, who, let me express my gratitude to his officials while I'm on the floor for their engagement with me earlier on this, but I would just caution that you don't create something that forces people out of the sector because the regulation is too burdensome, and that the people who are minding children perceive that they are under the cosh, as it were, in terms of changing the very dynamic of that relationship that they have with the children that they're minding, and that they are forced then to make changes to their own home, which is a private property, so as to fulfil the regulatory regime that the Minister proposes to introduce. We received correspondence from Childminding Ireland in which quite a number of testimonials were sent to them in respect of perceptions of people of what this new regime will look like. And it is interesting to quote from the document. I mean, I pick a few randomly, where the testimonies of childminders. One such testimony is, "I fear registering with TUSDA will become very expensive. Add on the additional and ongoing training and modifications to our homes, then the childminder's net income will be diminished." I'm quoting from the document. "When you reflect on the long hours currently worked, and then consider the amount of paperwork required, childminders' income will be greatly reduced in value. That's one. In my opinion, TUSLA are not the right body to govern childminders. Their NCS is anything but efficient, and childminders will be left without their wages if my own experience in the public sector is to go by. TUSLA keep changing the parameters for NCS and core funding, and I don't think the childminders would be able to cope with all the red tape. I work as a childminder, another one, believing it is my profession, and I'm proud of what I have had the opportunity to do. It's always been my intention to register on TUSLA. However, it is not correct for the government to regularise or change the childminding regulations simply to plug a hole caused by government failings, ineptitude and inefficiency. The problem won't be solved making things difficult when the proper government, and again I'm quoting, do not have appropriate public policy to attend to the demands of early education. I aim to continue this work for many years, but I do not wish to be a scapegoat when the government itself does not take care of this demand properly. I prefer to fight for the recognition of childminders as an essential profession in Ireland, as opposed to being a stopgap where we are only valued when there are no places available in a creche. I believe it is important to say that I'm against regulation of childminders, but the actual proposal of childminding regulations aren't going to fix the problem and make it harder for childminders like myself. It's the person's own syntax, but we totally understand the sentiment that's being expressed by the person, and I think we should respect that. So, I hope that the Minister, in response to the debate, will speak to the concerns that childminders of long-standing, who are, as I've said, an essential component of Irish society, where that relationship is a very special relationship between the childminder and the child and the parent and the childminder, that we don't do anything that will upset that dynamic by foisting a regulatory regime upon the childminder such that it will force them out of the sector. Because if that happens, and if it happens in numbers, then in a sector where there's already massive pressure and demand for places, that's only going to be exacerbated. I do think that the Minister is talking the language of appropriateness and proportionality, and has as its core the issue of safeguarding, and that's all laudable. But may I please ask that the right tone and balance is struck so that we don't force people out of the sector. The transitional period of 3 years. Can I ask the Minister to respond to the question of why 3 years? What is the rationale behind the 3 years? There's no requirement to register until the end of the transitional period, and this will ensure that childminders have time to understand and prepare for new regulatory requirements. When is it that the Minister proposes that the regulatory requirements will actually be in place? And as has been outlined by Deputy Mitchell, and I share her view on this, is there not scope now for further collaboration between childminders themselves through their representative organisation to tease out what the regulatory regime should look like, so that if we allow for the inevitability of the passing of this legislation, I'm assuming we take that for granted, that there is the space before you make the regulations to ensure that a regime will exist that doesn't force people out, and that they're based on pragmatism and understanding that nature of that relationship, which I keep talking about because I think it's vital in every community between the childminder and the child. There's a special place for it in every community, but that we don't create a regime that forces people out, and that you bring the childminders in and you tease this out further so that an understanding is reached to everybody's satisfaction. And that's my contribution.
Deputy Cathal Crowe is supposed to be our next contributor, Neil Shenshaw, who's next after that. Deputy Martin Kenny, please.
Corla, I think I have 3 minutes approximately. Yeah, Minister, first of all, you know, the discussions I've had with childminders in recent days in respect of this, who mind children in their own home, who provide a service and who, you know, accept that change needs to happen, and I have no difficulty with that. There is a certain scepticism and difficulty with it, and they feel and certainly have a fear of being overburdened with regulation in respect of that. And one person I spoke to said about how the issue of visitors coming to their home, about, you know, would they have to be vetted, and all of that type of issue is something that, you know, is certainly alien to many people. And you know, many of us grew up in an environment where people lived in each other's pockets in local communities, and, you know, often stayed and were looked after by neighbours, and all of that sort of thing happened in a very ad hoc sort of way in many communities, and it was to the betterment of those communities that happened. And we certainly don't want to see a situation where people would feel that they would be constrained in any way if they offer a service to look after children in their local community. And while at the same time as it would open up the possibility of people having the option of getting, you know, some compensation for that, some element of recognition and all of that there, if it's going to put more people out of the business and away from it, it fails. And I think that's what needs to be recognised. And I acknowledge this is the very early stages, or, you know, this bill has a distance to travel, and I would hope that the Minister and the Department will be open to amendments in respect of it that would deal with these issues. The biggest thing I think that has come across, and indeed other contributors have mentioned it, is the whole issue of adequate consultation with people involved in providing the service, and ensuring that consultation is open-ended and is there to try and assist people to move into the correct space. Many people, as I say, have that certain fear of, you know, this over-regulatory authority coming into play. And, you know, TUSLA, and we all have dealt with them at various times, do a wonderful job and are often, you know, the first line of defence when it comes to protecting our children and protecting rights and all of that. However, sometimes people have a great fear of the way in which they can deal with things, and how strict and how black and white they can sometimes see things. And I think that's something that needs to be recognised in the context of all of this as well. So, Minister, I would hope that you would recognise that the legislation that we're presenting here today is far from the finished product. I think we need to understand that. And I think whatever changes need to be brought to it should be recognised that they will be offered from the opposition, and hopefully from yourself when we see some of the consultation and the outcome of that you would be open to, I think, considerable change to ensure that people can find a way to embrace this legislation, and to ensure that we can find more people who will be prepared to look after children in that home setting. Because so far, all the difficulties we've had in our childcare process has been the corporate sector. That's where the problems have been, not in the other sector, which unfortunately this legislation would throw a blanket over all of it. And I think that needs to be acknowledged, that there has to be changes in respect of what you've been presenting here, and hopefully that will happen through the process as we move forward.
Deputy Roisin Shortall now. We must interrupt this debate at 4:31. So if you're still in possession at that stage, I'll ask you to move the adjournment. Deputy Shortall.
Probably be done. Okay, thanks, Count Corda. I welcome this debate on the Childcare Amendment Bill 2024, which I'm taking in the place of my colleague, Deputy Jennifer Whitmore. And at the start, I just want to say that I'm quite disappointed that this bill has been so drastically pared back. So much so that only 7 of the Children's Committee's 96 PLS recommendations are now relevant to the bill that's before us. Extensive provisions on child welfare and protection have been put on ice, and you know, that's regrettable, I think. We're told that another bill will be published later this session, and the importance of honouring that commitment, I think, cannot be overstated, and I'm sure you accept that, Minister. It's a year since the PLS report was published, and over 6 years since the review of the Childcare Act 1991. We should be further along the process at this stage. At the very least, I would hope that this time has been used to strengthen the outstanding bill, to take account of the Children's Committee's recommendations, and indeed the recommendations of the Ombudsman for Children. Amongst the many observations made by the Ombudsman was the draft bill's weakness in respect of unaccompanied children seeking asylum, which is an increasingly pressing issue, as you'll know. This followed a 2020 report by the Ombudsman, which found that more than 120 unaccompanied children were housed in hostels with no care staff after 5 p.m. The likelihood is, of course, that that number has increased significantly since then. While a noteworthy investigation published in December 2023 found that 62 asylum-seeking children have disappeared from state care since 2017. That's an absolutely shocking figure. It represents a complete abdication of responsibility to those children, and it really is quite an indictment of the government, in my view. I accept that there has been an unprecedented increase in the number of unaccompanied children arriving in Ireland, but a country running a surplus of €8 billion should be able to meet that demand. We have not just a legal, but we also have a moral obligation to protect these very vulnerable children. It's also worth noting that it's almost exactly a year since researchers in UCD published their shocking and disturbing report into the sexual exploitation of young girls in state care. That report found that girls as young as 12 were being horrifically abused and deliberately targeted by predators. But that was not the first time that the government has been alerted to the sexual abuse of children in state care. I think the government has been on notice of this abhorrent abuse since at least 2020, when Tusla was notified of concerns about a sexual exploitation ring targeting girls in state care. In view of these shocking state failures in the care of vulnerable children, there can really be no excuse for any further delay in advancing the child protection provisions that we were promised. Returning to the bill before us then, clearly a stronger early years and childcare regulatory framework is needed to protect children. This was brought into sharp focus by a 2019 RTE Investigates programme, which revealed serious breaches of the existing regulations in 3 early years services. While I appreciate the concerns expressed by some representative groups, legislative change is undoubtedly required. A do-nothing approach would not be sustainable, nor indeed in the best interests of children. The additional enforcement powers provided for in this bill were recommended by the Regulatory Impact Assessment and supported during public consultation. Around 60% of participants in that consultation agreed that the regulator's powers should be strengthened. The bill also acts on a commitment made in the National Action Plan for Childminding to remove the legal exemption for childminders from registration. This in turn allows for the opening of state subsidies to parents availing of childminders. This, it should be noted, is a significant cohort of parents. A 2023 ESRI report on extending the National Childcare Scheme found that childminders are the second most widely used form of paid childcare in Ireland. Their research found that of all current non-relative childminders registered with Tusla and all eligible parents claimed state subsidies, this reform would benefit 80,000 children by an average of around €100 a month, and that's very significant. However, it should also be noted that a recent survey carried out by Childminding Ireland found that almost 31% of childminders and nannies surveyed did not intend on registering with Tusla, while almost 19% didn't know whether they would or not. This is quite a worrying aspect of that consultation and points to the need for greater engagement and consultation with the sector. The Children's Committee specifically recommended that the regulations for childminders should be, and I quote, proportionate, appropriate and specific to the setting. and that the sector should continue to be involved in the development of those regulations. The National Action Plan for Childminding also emphasised the importance of consultation. However, Childminding Ireland has expressed serious concerns regarding the current draft regulations and the level of consultation carried out. They're calling for the Minister to engage in what they refer to as a real and meaningful process of engagement. Ultimately, the Minister's guiding policy principle when implementing reforms, of course, should be supporting and respecting choice. That's why this regulation, which is welcome, should be proportionate. And I think it's important to bear in mind sometimes it's, notwithstanding the progress that has been made in group settings, I think very often the assumption is that parents want to have a kind of a group setting. That's their first choice, and it's not. And I'm going to talk about this just in a couple of minutes, a bit further in relation to parents' choices. But of course, the first choice generally of parents is that one or other of the parents are in a position and supported to care for their child during the first year of life, and that's recognised by the Programme for Government, and we still have some way to go on that. But it's also a very conscious and valid choice in many cases that somebody would choose a childminder to mind a child in their own home. And this is, as I say, a conscious choice, and many parents want to have a setting that's close to a family home setting. And that's why we should avoid any attempt to just transpose the regulations that apply to group settings to the childminder's home setting, because it is quite different. And I think a lot of parents want that kind of more homely feel. And I'm not suggesting it's an easy thing to do to regulate that, and a very delicate balance, I think, needs to be struck to maintain the real positives of a childminder's home setting, and not over-regulate it, while at the same time ensuring safety. So as I say, I'm not saying for a moment that that's an easy balance to strike, but it's an important one to aim towards. And, you know, we don't want the state to be inadvertently limiting the choices of parents. Enabling choice, of course, is not just about supporting the formal childcare options. The state must also do much more on paid leave entitlements. I acknowledge that parents' leave and parents' benefit will be extended by 2 weeks in August, and that's a very welcome development. But that is really the bare minimum required under the EU Work-Life Balance Directive. Certainly we in the Social Democrats believe that much more radical reforms are required in this area. We know that the first 12 months of a child's life, as I say, are hugely important, and that's recognised in the Programme for Government. And, you know, it's important that there is delivery on that recognition and that commitment, and that many parents we know that many parents would like the choice to care for children in their own home. But that, of course, isn't an option for a great many people. And what in many cases it has become is an option only for those who are in very well-paid jobs or very well off, where one parent can afford to take time out of the workforce. But when so many couples rely on two incomes to either pay the mortgage or pay rent, to pay their energy bills, and all of the additional costs associated with having a child, they can't absorb the inevitable fall in household income, which, you know, parental care in the home entails to a very large extent. Therefore, the state has to step in. Ahead of Budget 2024, we in the Social Democrats proposed increasing paid parents' leave to 13 weeks per parent and increasing benefit payments to that level that was recognised during the COVID period, the COVID payment of €35 per week for maternity, paternity, adoptive and parents' benefit. This would have provided for the full first year of a child's life through paid parents' leave and maternity leave. In the longer term, the state should increase the overall amount of paid and unpaid leave for parents to the European average, and that European average is currently around 100 weeks per child. So we have some distance to go to reach that European average. All of the evidence shows that there are significant benefits in doing so, and that's why the Social Democrats have consistently called for a significant extension of paid leave, and I hope there will be further progress made on this important area in the upcoming budget later this year. Because after all, we know that parents should be more than just should be able to do more than just survive on a week-to-week basis. The state can and should support parents in all forms of families by allowing them more time with their children during that critical first year of the child's life, and more help should be available in terms of the costs that all families endure and experience while raising a family. And that's the position we need to be in, to recognise those costs that are involved, to encourage people to have children, and to ensure that the cost of providing for children and spending good quality and quantity time with them isn't prohibitive, and that's why we need to move to the European average in terms of providing those key supports during the first couple of years of a child's life. Thank you.
1 minute remaining. Deputy McGuinness is next, but I'll have to ask you to propose the adjournment at 4:31.
At 4:30?
31.
So can I just start by welcoming the bill, I suppose?
Yeah. Up to
Do I
yourself.
propose the adjournment now?
Well, no, it's not 4:31 yet. I'll tell you.
Oh,
when
I
it
see.
is.
Oh, very good, yeah. So I welcome the bill, and I have a few concerns that I want to express, particularly about the childcare sector, both the private care, the community care, and the interaction with TUSLA. I know that there's a need for regulation, and there's a need to continue to supervise how children are looked after, that they get the proper care and attention, and that they are that there is a response mechanism there to any issues that might arise. My experience with TUSLA in relation to a complaint I made recently was that the phone wasn't answered. And I'm still waiting for a call back from TUSLA to register a very serious complaint, and they haven't called me back. So that doesn't say much for them. On the other hand, I have seen cases where a lady lost her home. She was a foster parent and ran into difficulty. She didn't run into difficulty, actually. TUSLA got involved, and they refused to engage. She fought in the interest of the child she was looking after. And in the course of that fight, she lost her home. I know that Deputy Troy, I think, was in touch with you, Minister, in relation to this particular case, and nothing has happened. The family is broken.
I ask you to propose the adjournment.
The child is still there, and I would ask that maybe in the course of the next part of this debate, I'll be able to bring the details of that here. I propose the adjournment.
Thank you very much, Deputy.